everyone, and welcome to Understanding Special Needs Trusts and How to Fund Them. Workshop today with Glenn Jarrett, Certified Elder Law Attorney at Jarrett and Luitjens, and Jan Knutsen, Financial Representative from Grace Financial Strategies. All of our workshops, including previous ones, are recorded and can be watched on our VFN YouTube channel. The link is on our website, which is vermontfamilynetwork.org. Everyone who registered for today's workshop will receive a follow-up email with a link to this recording, as well as a PDF of the presentation. So Vermont Family Network has been serving families of children with special health needs and disabilities and the professionals who serve them for more than 30 years. We are the federally designated Parent Training and Information Center, the Family to Family Health Information Center, and the Vermont chapter of both Family Voices and Parent to Parent USA. Today's workshop is being recorded, so please keep that in mind as you share information about your situation in the chat. These sessions will include live captions. If you want to turn them off, click on Live Transcript, then hide subtitle. If you're comfortable, you're welcome to turn on your camera. You can ask questions using the chat box, which you'll see at the bottom of your screen. Feel free to share information or links to resources that you found helpful in the chat as well. We know you can all learn a lot from each other. So I'm excited to introduce you to Glenn Jarrett and Jan Knutsen. Thank you so much for joining us today.
Thanks, Karen. Appreciate it. Glad to be here.
Yes. Good evening. Nice to see people, even though I can't see you really. And I guess I'll start and Jan will do the second part of the presentation. It's really heartwarming to be able to speak to a group of people like this. I've been doing special needs planning for almost 20 years, and I know some of the challenges that people face in dealing with a family member or loved one who has special needs. And I know it's difficult to take an hour out of your evening to listen to talking heads, but we'll try to make it somewhat interesting, and we'll take questions at the end. Next. So when I talk to a client about a loved one, there are certain steps to go through to determine what the best course of action would be. First question is, does the beneficiary have a disability? Because if not, there's no need for a special needs trust. There could be a different type of trust that could take care of that loved one. And that could be a discretionary trust or a support trust, or even giving the person a lump sum of money as an inheritance or a gift. The second question is the beneficiary sufficiently disabled to qualify for needs-based public assistance? And next, please. The most common definition is that in the Social Security Act. You don't need the cite. Next, please. And that is basically if someone is unable to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairment, which can be expected to result in death, or which has lasted or can be expected to last for a continuous period of not less than 12 months. And that's a mouthful. So it's not just a short-term disability. It's got to last for at least 12 months or be expected to result in someone's death. And in monetary terms, the amount of money that someone can earn and still be qualified for Social Security disability is this year $1,310 per month. So if someone has the ability, even if they're not earning that much at the time, but if they have the ability in the eyes of the examiners who make these decisions, to earn more than $1,310, they won't qualify for Social Security disability. And we'll talk about the programs in a couple of minutes, but this is the definition used by both of the major Social Security programs, which is disability and SSI, supplemental security income. Next, please. So I got to keep up here. And for SSI, supplemental security income, which is the basic benefit that people who haven't worked long enough to get Social Security disability may qualify for. The person has to be either 65 or over, blind, or permanently and totally disabled. And that definition is on the previous slide. Their income has to be below the SSI benefit amount. And this year, that's $794 from the federal government plus $52.04 from the state of Vermont. So it's about $845 is the SSI benefit amount, and that's the most you can get on SSI. And they have to have countable resources of $2,000 or less, and if they're married and living together, they can have $3,000, which is not very generous. But there are certain resources or assets that are considered to be exempt. Next, please. And Medicaid is a joint federal state program. It's Title 19 of the Social Security Act. And as I noted in the slide, each state has its own laws and regulations about Medicaid. So it's very difficult to compare a Medicaid program in Vermont to a program in some other state. Now, in some programs or some benefit programs, there isn't much of a difference because the federal government does a lot of the rulemaking. But in long-term care Medicaid, which is not tonight's topic, there are big differences between states. So don't think that you can know everything about Medicaid by knowing what Vermont Medicaid or some other states Medicaid is like. So there's a federal agency called the Centers for Medicare and Medicaid Services that administers Medicaid, and many states, including Vermont, base their Medicaid eligibility on SSI qualification. And what that means in practice is that if someone qualifies for SSI, they automatically get Medicaid in Vermont. About 2/3 of the states follow that rule. Next, please. And some other programs that people may be able to take advantage of are some assistance with housing. And the SSI program and the Medicaid program both have income and asset tests, but the housing programs are income-based. So assets are not as important. And the two primary programs are the Section 8 Rental Assistance Program and the Section 202 program. And with these programs, the idea is that the tenant doesn't have to spend more than 30% of his or her or their income on their housing if they qualify and they can find an apartment or a house. And there are other programs that are less well known, a group home program or some independent supported living. And states often have nonprofits that administer these. I think in Burlington area, it's mostly the Howard Center that does that. And Medicaid or SSI qualification is often required to participate in those programs. Next. So what happens if a beneficiary has too much income or too many assets? Well, it doesn't mean that they shouldn't do some planning because in the future, they may qualify. They may have a change in their assets or income And it will be important in some cases to qualify and to do a special needs trust, especially if that beneficiary is approaching age 65, because as we'll see in a minute, after they turn 65, there is one important type of trust that they cannot take advantage of. Next. And when I look at what type of trust is needed, the first question I ask is in red, whose money is it? Because sometimes a beneficiary will have money of their own, and they may have recovered in a personal injury case. Maybe they were in a car accident and they got a recovery, or they may have gotten an inheritance and they have more assets than are allowed for the program that they're interested in. And in other cases, it's someone else's money. For example, parents of a child who has a disability. And we have two main types of trusts in the special needs area. One is called a first party trust, also called a self-settled trust. And the beneficiary is considered to be the grantor or settlor of that trust. And if the beneficiary has money of their own, that is the type of trust they will need. In some cases, people need both types of trust, because the third party trust, when it's someone else's money, is useful for parents or other relatives who want to leave some money to their loved one, but not have it disqualify them from government benefits. So both types of trusts will insulate the assets that are in the trust from being countable for benefit purposes. But if it's, and we'll see in a minute why it's important to differentiate between these. And we might as well go on to the next slide now, please, Rachel. So the first type of trust is what's called a D4A trust after the statutory section in the law. And it is designed to hold assets of the beneficiary, and who has to be under age 65 when the trust is created and funded. And there are limited people who can create such a trust. The beneficiary who has capacity, is able to understand and take actions on their own, can do that or by themselves or through their agent under a durable power of attorney. A parent or a grandparent may also create such a trust, as well as a guardian or a court. And in 20 years, I've only seen one instance where a court actually created a special needs trust, so I wouldn't count on the court doing that. But it's less than 5 years ago that the law was changed to allow a beneficiary to create this kind of trust by themselves. Before that, it was a parent, grandparent, guardian, or a court. Next, please. And the two or three key things to remember about this type of trust with the beneficiary's assets, a first party or self-settled trust, is, first of all, this isn't on the slide, it has to be for the sole benefit of the beneficiary. Other people cannot benefit from it except incidentally. So in other words, a trustee of this kind of trust could not make a gift to a third party on behalf of the beneficiary, because that would violate the sole benefit rule. And secondly, the trust, once the beneficiary dies, cannot be distributed to other people in the family before Medicaid is taken care of, because this is kind of a trade-off. In return for not counting the assets in this type of trust for benefit purposes, the money in the trust will go to Medicaid first upon the person's death to reimburse Medicaid for the expenses that they've laid out money for during the lifetime of that beneficiary. And I was just working on a matter today where there was such a trust that was created, and there was about $50,000 left in it when the beneficiary died, but the amount of money that Medicaid was owed was over $200,000. So all the money in that trust is going to go to Medicaid to pay them back. If there were funds that were remaining after Medicaid was repaid, they can go to other beneficiaries who were designated in the trust, including family members of the beneficiary who died. Next. Another type of first party or self-settled trust is called a D4C trust. There won't be a quiz on these numbers and initials. It's also called a pooled special needs trust. And this, again, is for the assets of the beneficiary, but it's different than the D4A trust in that it's associated with a charitable organization or nonprofit that runs the trust. And instead of creating a trust just for that one beneficiary, they have a master trust that lawyers have created, and a person who wants to get into that can just join the trust. They don't have to have their own trust. So they sign on, and there's a trustee who manages the money, and it's less expensive than doing your own trust, but it also has another layer of bureaucracy in it. And it can be useful, but it may not be for everyone. There is somewhat of a question in the law because of some discrepancies and whether or not this kind of trust can be created after age 65 without a penalty. And in Vermont, the answer is probably not, which is what most states say. Next. The third-party special needs trust. Now we're shifting from the assets of the beneficiary to someone else's assets. And because they belong to someone else, for example, parents of the beneficiary, they're not considered to be owned by the beneficiary. Next. So to look at differences between first and third-party trusts, we've talked about these, and I'm just kind of summing up. But other things, the trustee of a pool trust can't be changed. It'll be the nonprofit or a bank or trust company that they chose, the nonprofit that organized this trust. A D4A trust can be drafted to allow a change in trustee, either by a court or a trust protector or a trust advisor, which are roles that are sometimes, but not always, put into a trust like this. And as I said earlier, the first party trust must have the Medicaid payback provision. And I didn't emphasize this next part enough. A third party trust, that's where the assets are someone else's besides the beneficiaries, does not have to contain a payback to Medicaid. So if parents want to provide for a child who has special needs, they can set up a third party trust. The money will be used for their child's supplemental needs during his or her lifetime. And when the child dies, other family members or charities can get the remainder of the money in the trust. Next. So a third-party special needs trust is not considered an available resource. It can be, it's used, as I said, for the supplemental needs of the person with special needs. And it can be done in one of two ways. It can be incorporated in, say, the parent's estate plan as part of their will or trust, or it can be drafted as a standalone trust, meaning it exists now. If it's in the parent's will or living trust, it won't get funded until after the parent or parents have died. But a standalone trust is, in effect, once it's created. Next. And as I said, the death of the special needs beneficiary, the trust money remaining will be paid to designated beneficiaries. There's no need to reimburse Medicaid, and it should not include support language. And that's a key thing in the legal nitty-gritty or technical stuff, because if the trust is there to support the beneficiary, then the state or the federal government could say, well, you can use the money in the trust up before we have to pay any benefits for this person. So it should be fully discretionary, meaning there's no requirement that the trustee use the money for any particular expense or to support the beneficiary. Next. And the standalone trust can be either revocable or irrevocable. And if you want to pronounce it revocable or irrevocable, doesn't matter to me. Meaning revocable trusts can be changed more easily, and irrevocable trusts, it's more difficult or impossible sometimes to change them. They can be used by third parties like grandparents, for example, to make a gift during their own lifetime or through their will or trust. So if you have other relatives who would like to donate money to the special needs beneficiary, they can be asked to change their will or their living trust to benefit that person when they die. Next. This is an abbreviated presentation, but I want to talk a little bit about ABLE accounts, because sometimes they're cited as being an alternative to a special needs trust. And an ABLE account was created by the federal government in 2014. And a couple of years later, a few states established the first programs. And Vermont has one, they call it the stable account, and it's run by the state treasurer's office. And there are some other qualifications that are not true of special needs trusts for an ABLE account. It doesn't work unless the beneficiary became disabled before age 26 and receives SSI, Supplemental Security Income, or SSDI, Social Security Disability Insurance. And the ABLE account does not affect Medicaid eligibility. It only affects SSI benefits if there's more than $100,000 in that account. And the overall limit on assets, which goes up a little bit each year, is $501,000. Another thing about ABLE accounts is you cannot put a large sum of money into such an account. The maximum that can be contributed is $15,000 per year. Next. And the money that's in that ABLE account can be spent for all sorts of expenses, some of which are listed on this slide. It's a pretty broad list of things that it can be used for, and it can come in handy. But as I said, you can't put a large sum of money, over $15,000, into it in any one year. So it may have limited utility if there's a lot of money from a settlement or an inheritance. Next. And the beneficiary does not have to reside in Vermont to join Vermont's program, but could, and conversely, someone in Vermont could join an ABLE program in another state. The beneficiary can only have one ABLE account. And as I said, it's limited to $15,000 per year. There is a Medicaid payback requirement for an ABLE account, just like in a first party or D4A trust. And if money from this ABLE account is spent on things other than what are called qualified disability expenses, which was the list on the previous slide, they'll incur income tax and a 10% penalty. Next. So in deciding what kind of trust to draft, there are some basics, and this is probably a little more technical than it needs to be, so we're not going to spend any time on it. But one of the key questions with a third-party trust where the money is not the beneficiary's money is, should it be revocable or irrevocable? And it depends on the situation, as so many things do. If parents are divorced, for example, they probably wouldn't want the other parent taking the money and going somewhere with it. So it might not be revocable in that situation. And next, please. And as I mentioned briefly earlier, there could be a trust protector or trust advisor whose job is to look over the shoulder of the trustee who's making the decisions about how the money is spent. And then another question is, where would that money go when the beneficiary dies? Because remember, in a third-party trust, it does not have to go to Medicaid. Next. One question that comes up often is, who would be a good trustee? And it can be a difficult thing. People's normal inclination is to choose a family member who they think would do a good job, and that may well be the case. But sometimes they might have to look elsewhere because maybe they don't have enough family members who are responsible and can do this. So this is kind of a list of what an ideal trustee would have or be able to do. They would use their discretion and act in the best interests of the disabled beneficiary. They have to understand public benefits and keep up with changes in the law. They can invest the money wisely and conform to all the requirements of the law and regulations. They should understand taxes. They keep perfect books, and they can provide advocacy and prevent abuse of the beneficiary's money. Next. And finally, they should be immortal, because every person that you can think of as a trustee will die at some point. And therefore, if you choose an individual, you should have at least one and preferably two backup people who could act as trustee. Or some people will choose to go with a bank or trust company to act as trustee. And one of the advantages of a bank or trust company is they don't die, but the people may change that you're dealing with. And not all banks and trust companies have a great deal of experience administering special needs trusts. So it's a good idea to talk to a prospective trustee and find out how much experience they've had. Next. And part of special needs planning is not just beyond creating a trust, is to look to the future. And we advocate using a team approach with an attorney, a financial planner, or a life care planner, and possibly an accountant or a care manager. And there are questions that the parents or other people who are planning for this young person, let's say, have to consider. Who's going to care for the child? Will one of the parents stay home? Is there enough life insurance for the parent or parents who are earning money? Education issues, special ed is a whole area by itself. And retirement assets can be difficult to deal with sometimes with a special needs trust. Janet's going to talk about that a little bit. But what we recommend people do is to create a letter of intent, which can be just written down. It can be a video. And the idea is to let a prospective trustee know all about the person who's the beneficiary. And in some cases, it doesn't have to be all that detailed, but then there are beneficiaries who may not be verbal and can't express themselves, don't know, who their doctors are, when their next doctor's appointment is. But it can go well beyond just facts like that. It could be, it could include what kind of things make the person happy or make them unhappy, and how to deal with someone who may not be verbal. So it can really serve as a great guide for people that have to come in and pick up the pieces should something happen to the parents or other caregivers. Next. Finally, this is until the Affordable Care Act, otherwise known as Obamacare, came into being in 2014, it was very typical that someone who was on SSI, because they would get Medicaid automatically, would get into those programs. And also someone would have difficulty before Obamacare in getting regular health insurance because of the ban on pre-existing conditions and the lifetime cap on benefits. But Obamacare changed all that so that if a beneficiary has enough money, they might forego the government benefits and just buy health insurance on the exchange if they're not on Medicare or Medicaid. And I don't know how often that is used, but it can keep people from being limited to a fairly small amount of money, the SSI benefit of about $850, and might provide a better health insurance policy than Medicaid would provide. So that's just food for thought. And at this point, I'm going to turn it over to Janet. Thank you.
Well, good evening, everyone. And Glenn, that was fantastic. That was very interesting and just a great overview of this topic. So my name's Jan Knutsen. I'm with Grace Financial Strategies. And whenever I do a presentation like this, I'm required by my licensing and my compliance department to let you know the states that I'm licensed in. So bear with me, please. So I'm securities licensed in Vermont, Connecticut, Florida, Georgia, Maryland, Michigan, New Hampshire, New York, Vermont, Virginia, Maine, and Ohio. I'm life insurance licensed in Vermont, Texas, Maine, Minnesota, Florida, Connecticut, Georgia, Michigan, New Hampshire, New York, Virginia, Maine, and Ohio. Thank you very much for your patience. Okay, next, please. Okay, so my topic is, okay, how can we fund special needs trusts? Just as Glenn had mentioned, first party trusts and third party trusts have different funding criteria. So let's first look at first party. So first party trust involves the property or assets of the beneficiary, just like Glenn said. So this could include inheritances or court settlements. Next. Third party, however, like Glenn informed us, contains the life insurance, real estate, investment, retirement accounts owned by someone other than the beneficiary. Okay, so let's look at these individually. Next, please. Life insurance. Okay, so let's say a parent decides they want life insurance for the trust, for the benefit of their child. So in this case, the trust is named the beneficiary on the life insurance policy. Okay, so when that parent passes away, that death benefit would go to the trust. All right. Now, there are different types of life insurance that are used to fund these trusts. The first one, and the most affordable one, is term insurance. With term insurance, as probably many of you know, you purchase it for a specific length of time. Usually it's 10, 15, 20, or 30 years. So what that means is, if you buy a 10-year term policy, you'll have life insurance on yourself for 10 years. And then at that end, you either have to convert it to permanent insurance or it just goes away. Okay, but it does have the ability to be converted to permanent insurance that will never go away. Next, please. The other option is whole life insurance. Now, whole life insurance is permanent insurance. It never goes away like term insurance does. And it stays in force as long as you pay your premiums, okay? So thus the name whole life means it's covering a whole lifespan of someone. In addition, whole life policies build a cash value over time. And it also has the ability of being able to be converted into permanent insurance as well. Next, please. And lastly, this is the third most popular type of life insurance that's used. This is called indexed universal life insurance. So this is permanent insurance as well. As long as you pay your premiums, it'll always be in force. And a portion of the premiums that are paid go to build cash value within the policy. But in this case, the cash value, its growth is tied to the performance of an index, like the S&P 500. Right now, there are these types of policies out there that will have a 9% cap in terms of the cash accumulation. All right. And it also has a zero floor, which means you can never lose any of the cash balance that you've accumulated, but you have the opportunity to earn as much as 9% a year on that money. Next slide, please. Universal life insurance. This has been around forever. It's permanent as long as you pay your premiums. This one offers flexibility in your premium and the death benefit while you own your policy. Offers the cash accumulation. But this one, instead of being tied to the performance of an index like the S&P 500, it's tied to the performance of financial markets. In this policy, you would choose various mutual funds that you would tie your performance to. Next, please. All right, so outside of life insurance, the third-party trusts can also be used to house real estate, okay? Could be that the parents decide they want to put their family home in this trust, or maybe, let's say an uncle has some investment property and he wants that to go into this trust, okay? That's a possibility too. Another option for funding are investment accounts. So maybe the grandmother of the beneficiary, let's say, has a little stock account and she wants to put that into the trust, okay? That's a possibility. And lastly, the other option would be retirement accounts. But like Glenn said, these can get kind of tricky. And so this is where you definitely want to confer with a trust lawyer and estate planner to be able to make sure you navigate that correctly. Next. Okay. Thank you for your attention. Appreciate it.
Okay. We do have a couple of questions. Some were given to us before your presentation. I think a couple have come in during your presentation. So one of the questions, and for everyone else, feel free to put more questions into the chat as I go through what we have here. So one of the questions we have is, what kind of reporting of disbursements are required annually?
I'll try to take a stab at that, Karen. If someone is getting SSI and therefore Medicaid, they'll probably have to report to both the Social Security Administration and to Vermont Medicaid. It's not, doesn't have to be a full accounting with an accountant doing it. It's generally they want to see what the money's spent for, and they want to see what the balance was at the beginning of the year and the end of the year, but it's generally done once a year. If someone is on some of the other programs, there may be some recertifications involved. Medicaid does that. And also Section 8 will have a periodic recertification. One thing I didn't mention earlier about Section 8 is that while it's an income-based program and assets aren't counted, there's no limit on assets, they do look at asset balances and they will impute some interest to the asset. So if someone had $100,000 sitting in the bank, it wouldn't disqualify them from Section 8, but it would produce a little bit of interest, and that would add to the person's income and therefore increase their tenant rent a little bit.
Okay, thanks. At what age should we start planning for the trust to begin? Well, it's two questions, I guess. And then is SSI dependent on parents' salary after the child turns 18?
The second question is much easier to answer. Parents' income only matters until the child turns 18. Once they're 18, that's when they become adults, and the parents' income is not counted. So that's when they generally can qualify for SSI for the first time. As far as what age would someone start planning, it depends a lot on the situation. If it's a fairly standard situation, and there probably isn't such a thing, but if a child has a disability and would qualify for SSI when they're 18, they might start a year or two before that. But the child might need to have a guardian appointed. That doesn't happen until the child turns 18. But in other cases, if someone is very seriously impaired, they might want to do some of the planning at a very young age, just to protect the income sources that are going to support the child and to provide for life insurance or some other way of continuing the income.
Okay, we currently have a 529 plan for our child, but that may not be the best vehicle given that he will not likely enroll in post-secondary ed.
Yeah, I'm not all that familiar with 529 plans, which for college education, but they can be shifted to another person. I know that. And I'm not sure if they could be shifted to an ABLE account. It's possible, but again, there's that $15,000 annual limit on ABLE accounts. But
and Glenn, if I can interject here.
Sure.
So 529 plans are fairly restrictive in terms of how they can be used, how the beneficiary can use them. The money within a 529 plan can only be used for college expenses, okay? Books, tuition, that type of thing. So if you feel that your child will not be attending college, now might be the time to think about other options you may have for that money. It would probably involve moving that money into a different type of investment, right? That wouldn't have handcuffs on it, so to speak.
If it were to go into a special needs trust, would that be considered a first or third party funding?
Good question. I think a 529 plan is owned by the person that sets it up. It's not owned by the beneficiary, but
That is
Janet can
correct.
probably speak to that.
Yep, that's correct. Mhm.
Yeah. So it could be a third party trust if it was able to be transferred.
Right.
And then a related question then, if you have not set up a trust, special needs trust for your child, and then someone does pass away and leaves your child a huge inheritance that would disqualify your child from these benefits, what is the parent supposed to do then?
Well, I'm sorry, go ahead, Karen.
Right. Should then the family hurriedly set up a special needs trust?
Well, if the money figuratively touches the beneficiary's hands, in other words, if the inheritance is to the individual rather than to a trust for the individual, once the person who had the money dies, that beneficiary really is entitled to the money. So it would be a first party trust because it would be the beneficiary's money. And that's why I mentioned earlier, if you're setting up a third party trust and there are other relatives who might want to contribute down the line, even, you want to tell them how to do it and what the name of the third party trust is. That's where you probably want to set up a standalone third party trust so it was in existence before the people setting it up had passed away. so that other relatives can direct an inheritance to the third-party trust, and it won't have to have a Medicaid payback because it wouldn't be a first-party trust.
So if it is a standalone and it is sitting there, just in case someone does die and leave an inheritance, there has to be something to collect it.
Right.
In other words, you would have to set up an account even if you don't intend to fund it. Right then.
Yes. Well, if the person dies, then there's going to be money to presumably to fund something, and it would either go into a first party trust if it was just directed to the beneficiary, or if it was directed to the beneficiary's third party trust. There should be an existing trust, even if there's no money in it, just to receive those inheritances.
And that would probably look like a bank account?
It could be, sure. I mean, trusts have bank accounts all the time. I mean, it doesn't have to be invested in very exotic things. It can be a bank account or a CD, or, but I mean, it's not enough to just say this is the bank account for John Smith's Special Needs Trust, unless there really is a special needs trust for John.
Okay. Who should manage the trust once we are gone? I guess the parent.
So that's the key question. And I spent a little bit of time talking about how to choose a trustee. It's sometimes difficult. Very often people's first reaction will be, well, my other children will take care of their brother or sister and they'll be in charge of the trust. That may or may not be the best way to handle it. It can work fine in some cases, in other cases it doesn't work so well. So you may have to look a little further and find someone else who can manage it and act as trustee, or you may end up with a bank or a trust company. But one thing to keep in mind is that banks and trust companies are not interested in managing $10,000. They really require a fairly large amount of money to be managed to make it worth their while to do it. Often it may be $500,000 or a little bit less sometimes, but don't count on leaving, $10,000 or $20,000 and having a bank manage it, because they won't be interested in doing that.
So how much should one expect to spend on setting up a special needs trust? What does that range look like?
Well, I think it depends on how much planning you're going to do. You may need a financial advisor, life insurance person, an accountant, life care planner to figure out how much money is needed, because there may be, over a young person's lifetime, it'll be a lot of money. And the cost of doing a trust is anywhere, I can't really speak for other lawyers, but it's a few $1,000s, not, 4 digits, certainly nothing. But it's something that different lawyers may charge different fees for.
Okay. I've answered this, but I'll ask it anyway. Can information be shared regarding having an ABLE account that is tied to a third party special needs trust? Does this minimize or remove the Medicaid payback provisions?
It doesn't. An ABLE account is a separate thing, for want of a better word. It's not connected to a trust. So an ABLE account is really just an account that is run by, in Vermont, the state treasurer's office. But I believe that the beneficiary would be the person who manages that account normally, unless they're willing to let someone else do it for them. But in name, the beneficiary gets to manage it, but it's not connected to a first or third party special needs trust. It has different rules and different requirements.
Okay, and then it looks like this is a comment. Up to $27,760 per year can fund ABLE if someone is employed, but $15K if not employed.
That
so I think
may well be true.
About the
Yeah.
15,000. Mm-hmm. Okay,
Right.
let me see. Then I think this might be a comment. I'm a bit passionate about ABLE accounts. I fully recognize the benefits of both ABLE and trust, and each have their place. Recently passed tax legislation makes it possible to directly roll over funds from a 529 into an ABLE account. Oh, well, that's an interesting point. I guess that kind of refers to one of our other questions. Okay, so while it's okay.
I was going to look that up. Thank you, Karen.
Well, I guess thank you to Amanda Barrett. She's the one who put this comment in. So are there any other questions? And I think people can unmute themselves if they want to ask. Okay, wait, I see another question. Let me read it. Are there any low-cost programs to help set up trusts for disabled children whose custodial parent is also on disability and of limited means?
Well, one answer to that question is a pooled trust, which I mentioned a little bit. It can be either a first party or a third party pooled trust, but the costs of setting it up will be a lot lower than having a customized trust for the beneficiary, because it's as I said, joining a master trust that's already in existence. So it's not as time consuming or expensive as creating a trust that's customized.
How does one even find a pooled trust?
A very good question, Karen. There are no organizations in Vermont, to my knowledge, that sponsor a pooled trust. The one I'm most familiar with is in New Hampshire. It's called Enhanced Life Options, and it's based near Manchester. And I think their web address is elonh.org.
And one in Vermont could join one in a different state? Do these?
Yeah, there's no
Okay.
requirement you be a resident of that state.
Okay.
I've had a number of clients work with ELO, and they were happy for the most part, I think.
Okay, are there any questions? I'm not seeing anything else in chat. And again, people can unmute themselves if they want to pop up to ask any questions. Okay, does not look, Amanda, I see you.
Yes,
go ahead.
I had asked the question about linking the ABLE to a third-party trust. I had seen some information on the Special Needs Alliance website that referred to that. And I was quite curious about that. The population that I primarily work with here at Voc Rehab, there are instances where parents usually set up a trust if this family situation that makes sense. Often a lot of the consumers I'm working with, generational poverty, there's not necessarily any significant assets to pass down or that would be available. So we often talk about ABLE as a way for people to have that financial freedom, especially before they change the rules on the special needs trust. But Medicaid payback is often a conversation that we have with individuals, and it can be a point of hesitation, especially if they might have a dependent child or a brother or sister of having that Medicaid payback. So I had posed that question because I was really curious and hadn't really explored that with anyone. And I was just looking for some insight because it made me pause and go, oh, is there a possibility to somehow link it to have that payback provision not apply? For a family, I mean, they're generally speaking living below the poverty line potentially and are able to use an ABLE because they are saving a little bit from employment. So it's a curious.
Right. I think it I don't know of any way to link it to a trust, but I think also it would defeat the purpose of the statute as expressed in the law, which includes the Medicaid payback. So I don't know that it would be likely that it would be approved by the powers that be. But I think I agree that an able account is very useful for people that don't have lots and lots of money to pour into a trust.
I'm very optimistic that at some point Vermont will kind of get rid of the Medicaid payback for able accounts in particular. I know some states have done so, and I'm hopeful that it might be in our radar over the next 10 years or so.
Well, I'll look for you down at the State House, Amanda.
I would be there as a private citizen advocating for that.
Okay, we do have another question. When looking for members of one's team, lawyer, advisor, and so forth, what are some good questions to ask in assessing the expertise in the area of special needs trusts?
I think Janet can answer this also, but I think it could be how much experience someone has, how many trusts have they created, have they managed trusts before like this, and just get an idea of how familiar they are with the subject and the rules. That for me, that would be the biggest thing to ask.
Exactly. And the other thing too would be you want to be absolutely clear, especially when it comes to a financial advisor or a life insurance person. You want to be sure you understand what the fee structure is. That's really, really critical that you know that going in. There are some advisors that you pay a fee for their services. There are others that you don't. And then the advisors are compensated by the companies that they place business with. So, one might be a better fit for you. So you want to be sure you find out how these people are getting paid and who's paying them.
Good.
Okay, it looks like we're almost out of time. Does anyone have any last questions? Okay, well, thank you, Glenn and Jan, for today's informative workshop. For everyone else, you'll see the link to an evaluation in chat. Please take a few minutes to complete it so we can make improvements and also to fulfill our grant requirements. So really, please, please, please fill out those evaluations. We have many other interesting workshops coming up, and you can find details about those on the homepage of our website, vermontfamilynetwork.org, along with the links to the previously recorded ones. We have tons of information on our website, and getting connected with us is easy. You can follow up on Facebook or join our closed Facebook page if you are a parent. We have 2 closed groups, one for all parents of children with disabilities and special health needs, and one for those with adult children. You can also sign up for a monthly e-news or check out our YouTube channel. So I think we have some contact information in our chat. So we are here to help. Contact us by phone or email. Thank you again, everyone, and have a wonderful evening.
Good night, everyone.
Good night.
Good night. Thank you.
Thank you.